Hi, welcome back to my channel. Please like, comment, and subscribe. Were you injured in a maritime crash? It is crucial to seek immediate medical attention. In addition, consult a Chicago Jones Act attorney from our law office who can help you protect your legal rights and obtain the compensation you deserve. Maritime crashes can occur in various ways, including collision between vessels, capsizing or sinking of ships, fires or explosions on board vessels, and accidents involving cargo or passengers on board vessels. Maritime mishaps can also occur while someone works on a vessel, such as loading or unloading cargo. The need for maintenance and care in the maritime industry. Maintenance and care is a type of insurance that maritime staff access to cover medical management costs if they are injured on the job. Maintenance and care is an important safety net for workers in this dangerous industry, and it can help them get the care they need without worrying about how they will pay for it. The doctrine of unseaworthiness in maritime financial damages. The doctrine of unseaworthiness is another avenue of recovery for boat workers. The doctrine of unseaworthiness allows an injured worker to sue the vessel owner rather than the employer. Have you been injured in a maritime crash? You may be entitled to financial damages for your injuries. Contact a Chicago maritime attorney to discuss your legal options. Jones Act claims in the maritime industry. One of the first things you need to do when filing a Jones Act claim is to determine the statute of limitations. Under general maritime law, you have 3 years from the date of your incident to file a Jones Act lawsuit for workers' compensation payments. But there are some important exceptions to this rule. Physical damage settlements from work are financial compensation paid to hurt workers while working on a vessel on the water. The employer or the insurance company pays the settlements. They can vary depending on the severity of the physical damage. Seamen compensation claims have been the subject of much litigation. In particular, the Act has provided seamen with many benefits, including the right to raise claims against vessel owners and co-workers and sue for negligence. Under the Federal Employers' Liability Act, workers injured at sea while working can file personal injury claims. Unique aspect of work-related severe injury legislation that apply to injured mariner. To recover for your physical damages from the ship owner or operator of a vessel as a seaman under the Act, you must establish that your damages were at least in part your employer's fault. In other words, you must establish liability by demonstrating that a hazardous condition or consequence of a negligent act on the sea vessel caused on or contributed to the damages like unseaworthiness. Unlike other state workers and tradespeople hurt during their employment and can receive benefits under workers' compensation, the sole remedy for an injured sailor is to pursue a Merchant Marine Act lawsuit. A Chicago IL legal counsel will build a case using the Longshore and Harbor Workers' Compensation Act enacted to protect offshore workers. Medical care for injured offshore workers. Injured workers are often reluctant to seek help from company doctors, fearing that may be penalized or lose their jobs. Often, an accident occurs on the job, but the injured workers do not report it for fear of recrimination, leading to severe harm and even permanent disability. Injured workers have the right to seek medical help without fear or reprisal. Seamen have a right to maintenance and cure to ensure that the vessel is fit for its intended purpose. The ship's owner is responsible for providing seamen to heal injuries with medical supervision and treatment until they can return to work. An accident report in a maritime accident. The Jones Act requires that an accident report be filed when maritime crashes occur. The report must include information about the accidents and the investigation findings. The Act also requires that the accidents be reported to the National Transportation Safety Board. The seamen and fellow employees are a particular class of workers with specific rights and protections. As a seaman, you must know these rights and protections to take advantage of them if needed. Should you have any questions about the workers' compensation benefits or your rights as a seaman injured on navigable waters, you should consult with a Chicago maritime attorney at Roosevelt Injury Lawyers LLC. Contact us for a free consultation. Holding the liable party accountable where an accident occurred as a result of negligent act on the part of a crew member, the injured person may be able to bring a Jones Act claim in Lake Country. Cruise ship, offshore, or seaman worker has legal rights to file a suit against their employer for negligence if the employer fails to perform a reasonable action to ensure a safety working environment. You can file claims if Jones Act applies in your case. The Merchant Marine Act is federal maritime legislation that allows seamen hurt on the job to recover damages from their employers. To file a Jones Act claim, the injured person must be a seaman who was injured while working on a vessel in waters they could navigate. The average settlement amount in Jones Law cases. Settlements under the Jones Law are usually based on a percentage of the total value of the personal injury claim. The average settlement amount is typically between 30 and 40% of the total value of the claim. However, settlements can range from a few $1,000s to several $1,000,000. It is depending on the circumstances of the case. Were you injured or lost a loved one due to maritime crash? If so, please contact us. We will never share your confidential or sensitive information regarding your case. We can discuss your case and advise you on the best course of action. Legal benefits under the Merchant Marine Act Seamen for injured maritime workers. Once liability has been established against an employer, an injured seaman is entitled to temporary benefit known as maintenance and cure. Maintenance is a stipend paid to sailors who are taken out of their position by a physician due to their injuries. A cure is a medical expense reimbursement for doctors, medical appointments, for care, hospitals, medical bills, and prescriptions. Our Jones Act lawyers are experts on this subject and can help you learn more about pursuing a claim involving maintenance and cure. Further distinguishing the Act benefits from those typically afforded under maritime workers' compensation. A seaman may be entitled to significant financial recovery for lost wages, medical bills, disability, fringe benefits, and pain and suffering. Thank you so much for watching. Don't forget to like, comment, and subscribe.